All right, I think we're live. Hi, this is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup after a couple of hiccups. Brad, go ahead, take us away.
Okay. Oh, by the way, you didn't say for June 23rd because you always do.
Yeah, June 23rd. I'm sorry, my computer has been giving me some problems getting us online today.
Not a problem. And I was traveling. So, okay, let's start with a simple but very important holding at the U.S. Supreme Court. And this what it really ends an important question because it had divided a lot of the nation's courts of appeals. And the question was whether an individual who has no intent or ability to return to work can file an Americans with Disabilities Act claim. And the Supreme Court, very correctly so, of course, who am I to say they're wrong, but very correctly so, decides that no, you have to be a qualified individual, and that's defined as somebody who is capable of performing the essential functions with or without reasonable accommodation, right? And also intends to return to work. And in this instance, we just had somebody who had health. I mean, we don't have to get too much into the facts because they're not that important, but we had somebody who, sued under the ADA and couldn't return to work. Fortunately, now we have an answer, which was really based on what I thought was a plain reading of the statute, right? They said, Congress made it unlawful to discriminate against someone who, quote, can perform the essential functions of the job she holds or desires.
Hmm.
Holds or desires,
Right.
not has no intent on returning back from. So I think that's really, it's important, but it
Well,
matters.
I don't think you and I have talked about this, but when a case goes to the U.S. Supreme Court, I declare a holiday. Or when a
Ah,
firefighter case, because we don't see it very often.
right.
It's like once every other year. So it's a special day. It's a holiday, and I went out and bought a new Glock. So there we
Hey,
go.
all right.
That's how I
There you go.
celebrate. That's how I celebrate my holidays. But, and groundhogs beware.
Yeah.
But as I read the case, I think it was Gorsuch that decided it, and he's one of those the textual interpreters of the Constitution, which that's fine. I disagree with some of it, but that's fine. But the ADA is like, to me, is this big. All right. And the employment part of the ADA is this big. And what he's saying, and I'm surprised her attorney didn't argue it, okay? But what she's saying is somebody who's retired is not an employee, and therefore they can't sue under Title I of the ADA. But there's other titles, and there's public accommodation, there's a lot of other things, and I'm surprised that somewhere there isn't something. And I'm not a ADA guru, but
Well, they may
some
not have preserved them for review.
well, somewhere there isn't something in the ADA that prohibits government from discriminating against somebody with a disability, not under Title I
Right.
as an
Public
employee.
facilities or accommodations, public buildings, meetings, etc.
Benefits,
Yeah.
entitlements, which, pension is an entitlement, and so I'm I guess that's my surprise, is that they didn't make the argument that another part of the ADA might have applied. They only went under the employment part. And Gorsuch really kind of, or is it Kavanaugh? I'm not sure. I think it was Gorsuch, but really kind of drilled down on the fact that somebody who's retired is not an employee anymore.
Right.
And they also, just to make sure that the ADA didn't exclude non-employees, they said somebody who's applying for a job or someone who
Right.
wants a job
Desires.
would still
Desires a
be
job. Right.
included, okay? But somebody who's retired from the job wouldn't qualify. So interesting, they didn't get into the merits. They avoided the merits of the case. They just said you don't have really standing
Yeah.
to bring the case. And I think the merits would have been pretty interesting. I don't think she prevails on the merits, even if they got to the merits, because she's saying that you're
That's my
treating
guess.
me with 19 years on differently than you're treating somebody with 25 years on. Yeah. Okay. Well, it's different. It's different. Well, I got a disability. Okay, but you didn't put in 25 years and it wasn't a line of duty disability. So now I guess what she's saying is you can't discriminate between somebody with a line of duty and a non-line of duty, which we do all the time. Okay. And you can't discriminate against somebody with 19 years versus 25 years, which, again, I don't think she
Right.
wins when it gets to if it ever got to the merits, she wouldn't have won anyway. So why they had to play, again, I see federal courts doing this a lot, playing that game of keep away. We don't want anybody to get to the merits of their case. So if we could find a way for you not to
Well,
get,
but remember, merits are factual, could require a jury or more discovery. And if I had this case come to me, I would have done the same thing. Motion to
yeah.
dismiss. She said she doesn't want to go back, no fact in dispute,
Of course. So
and
let's,
doesn't
but let's
qualify.
read, and I agree. And let's replay this. This case started in, was it 2018 or so? So we're 7 years in. How long would it have taken for a jury trial?
Yes, a lot less, barring an appeal, but still,
Yeah, but
this
you get
issue
it.
then would
But
have
they
come
get,
up later.
and I think their rationale is they're playing the game. But I call it's keep to me, it's keep away from the merits. Let's play all these games and we'll never get to the merits. Now, if she loses on the merits, you don't have to get into this shell game over here.
Yeah.
But I don't know. I
I
don't
don't know.
know.
I'm a law kind of guy. I like winning on the law and avoiding the facts because I don't trust juries.
What was that? What was that saying?
If you don't
Sometimes
if you don't have the law, argue the facts. If you don't have the facts, argue
oh
emotion.
yeah, no, that one there, no, but sometimes one good witness is better than all the law. And
Yeah,
so, but
and one bad juror. But I know
yeah,
I
no,
just
I
don't
get
like
it.
juries. I don't
I get
trust
it.
them. They're a crapshoot.
Yeah,
So, okay, let's go to Seattle.
yeah.
You know, this is kind of shocking that it's coming up so late.
Mm,
But we have Seattle Fire Department is investigating the possibility that a number of employees were circulating and using false COVID ID or vaccination cards, right?
right.
And by the way, I have friends who did it. I'm not saying I supported them on this. I got vaccinated and, but and I don't support lying to your employer or any of this, but it was a pretty widespread practice. But some of these facts are interesting what they said. So this broke, I guess, in the Seattle Times, right? And they said that employees made, it looks like in 21 that they made these fake cards. And there, as proof, there are these app messages that were exchanged in 21 between a deputy chief. So this is potential fraud at its highest, and several fire personnel. And they talk about, they refer to like blank vaccination cards, which were possibly taken from a closed or one of the, now it's now closed, I guess, but another fire department vaccination kits. And they used phrases like, I got you a piece of art. They thought that was a coded reference to a blank CDC issued vaccination card. They hired an outside investigator. There are serious concerns over this. And there were so you got to think about it. There were 500 employees who were placed on medical leave or religious, right? Or they claimed a religious exemption, but they said, sorry, if you're not going to get vaccinated, then here's what, right? Here's what happens. You're on leave. But here, instead of claiming medical or religious or other exemption, they just allegedly filled out a fake vaccination card and turned it in.
Mm.
You and I think a lot of us were totally opposed to getting rid of your firefighters, healthcare workers. New York fired their freaking nurses, right? Thank you for serving all of through COVID when we knew nothing about it, and you're probably going to get sick and die and whatever. But now that we have a vaccination, we're going to fire you. Thanks, if you don't want to get the vaccine. I just thought it was repulsive of New York, California, and the others who did it. But every single court, right? When we go back to that C word, which we can't even say on YouTube.
Well, it's too late now. I think if we're going to get a strike, we just got it.
Yeah, I think I kept
Yeah,
saying it.
yeah.
I
So,
forgot. It's been so long, but
well, hopefully now with the change of administration, Silicon Valley and Google and YouTube are not under the government pressure to silence people from talking about it. But I guess we'll see. If we get the strike, we get the
and
strike.
that is what happened. Just so the
You
viewers
know,
know, what happened is years ago, you and I were reviewing a court decision about COVID,
and it
and we
wasn't,
didn't
we
say
weren't
anything
we weren't putting
about it.
our opinion in it.
Right, right. And they just right, even after you appealed it, they said you have to take it off.
Yeah.
And they removed it. I mean,
They removed it. Yeah.
anyway, so much for freedom of speech. But so who knows if this is true?
Yep.
I hope it isn't, but I totally understand it. I'm not saying I support lying to your employer. I
Mhm.
certainly don't support forging a public document. But
What's the saying? Let's turn the page. Let's just turn the page.
right,
We went through it. It was horrible. Let's turn
let
the
it
page.
be.
Let's move
Right.
on. And, anybody who, most fire departments today are struggling to get people. If you've got somebody sitting out there that was a firefighter a few years ago, that they have the skill set, you can get them back.
But
You know,
500 people on leave from that department is a huge number.
yeah.
I can't imagine how much overtime people were working, PTSD, all of that, right? Exhaustion. You're creating a medical issue by trying to prevent a medical issue, I suppose.
Mhm.
But look, we were crazy back then. I think the whole world went crazy, frankly.
Yeah.
Okay, let's do something more reasonable, at least, and let's go to Missouri, where the Court of Appeals, a higher court, has. I say this slowly because it's too many words. They agreed with the court who dismissed a lawsuit by a Kansas City firefighter.
How
And
many
this is
negatives? Double negative.
a lot of double, right. So they affirmed the dismissal, but they agreed with the lower court who kicked the case out.
Mhm.
So here's what it was about. It's a privacy case. The firefighter alleged that members of the Kansas City, Missouri Fire Department, not to be confused with the other one,
Mhm.
improperly disclosed his confidential medical and mental health information. Now, I have to say, I'm not so sure. Well, part of the whole thing I agree with because it's going to be statute of limitations, but some of this is a little strange. But this comes up a lot. And before I get to this case, this comes up a lot because I get to all the time. What if we went to our member, and I really do get this all the time, and he was heroin, right? Or tried to kill himself. Suicide, I get a lot.
Yep.
Or what are we allowed to do with the information with our employer? It's always a burning question to me. And he's a patient, so is it confidential? Then again, you're right. I mean, it just keeps going. It's a tough question.
Well,
So
it
here,
comes up in discipline as well. There was a chief, and I believe we talked about it, but there's a chief who got in some sort of an altercation with the police. The firefighters were there. He needed medical attention. They treated him.
yep,
And then that's how the fire department became aware that he got in an altercation with police. And
yep, and it's not protected. The medical information arguably could be protected. The
Mhm.
situation is not. All
Right.
right,
How
so
do you parse that out? I mean, how do it's,
very tough. They're very
yeah.
tough. But just because well, in short, and this is part of the whole thing here, but in short, just because you call your employer for help doesn't mean it's confidential from them. In any event, here in 2017, see how long this goes on, he was taken to the hospital for treatment. And he claimed afterwards that the city employees disseminated details of his medical condition to others inside and outside the fire department. Now, you can totally see that happening, right? There are no
Mhm.
secrets in the fire service. You can totally see that happening. But that's not the issue here. So he filed in 21, and over the next 3 years, he keeps amending the complaint, I think 5 times. And so he kept adding breach of confidentiality, breach of implied contract, violations of the Missouri Merchandising Practices Act. I can't tell you I have any idea what that is. Negligence, negligent supervision, and negligence per se. And so against that, the city then says, yeah, but we have immunity. So the court here first, and you're never getting away from this, kicks it out on statute of limitations. Just says, you know what? A lot of this just came too late. Sorry. You can't add some of this stuff now. And they wanted to add individual EMS personnel. They want to add the city privacy officer as a named defendant. He said, too late on those people. You should have had them immediately. As to sovereign immunity, he said you can't raise the theory that the city was acting in a proprietary capacity, and they'd gone through too much litigation. So I believe the court said they are immune, and you can't raise the theory that this was all proprietary versus governmental immunity. And then they say, HIPAA is not a contract. Now, I actually had this case. I won the first case in New York on this, but there are a lot of cases federally that says there's no private right of action. You can't sue under HIPAA. And the court deals with it differently. They said, you have privacy in this very interestingly way. They said, well, look, there are privacy obligations And so I think this is on the breach of contract. He's trying to say that you can't promise to do something that you're legally required to do. So you can't breach a contract, breaching the HIPAA contract, so to speak, because it's a law, and so you can't breach what you're required to do.
Well,
Anyway,
is it a breach, or is it that there's no consideration? It's not a contract.
I I don't know. It doesn't form the basis of the contract, right? So
Exactly.
it could
Yeah.
be void for a lack of
There's no,
consideration.
like, when you agree to do something you're legally required to
Yeah,
do,
I would say it's no consideration, right?
there's no consideration. Yeah.
Yeah, which makes sense. By the way, I'm filing a lawsuit in a week with that exact point. Anyway, can't say who. So this you make the point correctly, right? This is why it's so hard for public employees to overcome sovereign immunity protections. But here's the thing: they blew it at the beginning. He blew it at the beginning. I don't know if he was pro se or not. I assume not, because usually it says that. But you got to get it right from the beginning. You get one chance to amend. Normally, what I do, just so practitioners out there, I'll file a lawsuit, do my best job I can. But in New York, at least, and many other states, I presume, once you file the suit, then they answer, right? They respond, they point out all the flaws in your lawsuit. And in New York, we get 20 days to amend the complaint as of a right. So I use that answer as a time to fix any errors, any holes I have in my lawsuit. And I've got to imagine sovereign immunity was probably raised and they could have fixed it early on. And they didn't. And I would be saying that's laches. I'm shocked that the judge allowed him 5 attempts to keep amending this complaint. I've never seen 5. I mean, I'm not saying there isn't, but that's a very liberal judge, which is why I thought maybe he's pro se, because judges are much more lenient for somebody without a lawyer than a lawyer
Yeah,
who
I
has a
don't
lawyer.
have the complaint, so I was just looking to see if I had it in my database. I don't have the complaint. It's a state court complaint, so I don't have all of
I
those.
got to imagine. But I'm just guessing. Um, okay. This next one is interesting. We have California. They've rejected a disability discrimination claim that was brought by a hazardous materials employee. So once again, the California appellate court, same language, upheld the dismissal, right? They agreed with the trial court who dismisses, in this case, a disability lawsuit. Now, this was not by a firefighter. This was by a civilian employee who works for the fire department. We've seen other cases. The highest ranking, LA fire civilian employee was part of another one. In any event, so we have this non-firefighter, but who is part of the county's hazmat division, which is managed then by the fire department. And there are sworn and unsworn officers. Her role, however, is data management and regulatory duties, not responding in any way. She's not a first responder. So in 2019, she suffers a non-work related injury, not on the job, not in the line of duty, went on a protective leave under the California Family Rights Act. And then unrelated to her, and this is so key, and this is true in every McDonnell Douglas, every discrimination claim. Why did you take action? Was it because of that person? You're discriminating, you're trying to impinge their rights, or you would have done it anyway. And here the court looks correctly and says that the county implemented a previously planned structural change where basically they decentralized the processes she was involved with, reassigned certain of her responsibilities. Her position is shifted from her unit to an enforcement unit, and the job title and description were the same, but they were going to do this regardless. They weren't trying to hurt her. They were just changing the job, and that's a question of fact. Obviously, the county proved, look, we had long before she was disabled or having nothing to do with her, we were going to do that. Now, here's the next part. I'm not totally sure I agree with this part. This is the problem. When she wants to come back, which is now in November of 2019. So we're going from March of 2019 to November of 2019. She wants to come back, and there were no vacant positions that she held in what's called the HMS 3 level. So she was offered an HMS 2, presumably a lower level, and she said, you discriminated against me because I have the right to come back to the same position. Now, if this was under family medical leave, she would have had that right. I am shocked that under any California law, she didn't have that right to her position back. But under family medical leave, under some states paid or unpaid leave, you have the right to the same position. If you're military, right, you go on military leave, you have the right to come back to that position. But here, apparently
You
there's
do
no
for
right.
12 weeks, right?
12 weeks or 26 if it was military, but 12 weeks under family
Well,
medical,
12
but
weeks. So,
that's
but
expired.
what happens if she has 6 months of sick leave and now she's gone beyond the 12 weeks?
It depends if they run it concurrent, right? If they
Right.
ran, and FMLA gives you the choice, the employer the choice.
Mhm.
Hopefully, presumably, they ran it the sick leave concurrent with the 12
Well,
unpaid weeks
with the first 12, but
with the first 12,
at
right?
the end of the 12, if you can't come back, you've got sick leave. We're going to continue your sick leave, but you don't necessarily get your job back.
Right, and there's no right now
Right.
to your job back because FMLA doesn't apply
So
anymore.
I think that's probably more like what probably happened here. That it is possible to still be on sick leave,
Yes,
but you've
not have
run out of
FMLA.
your FMLA leave, and your employer, most employers, I think, when you've accrued that much, they will allow you to take it. But there's no federal obligation, and I'm sure California's isn't unlimited, even if California's is 24 weeks. If she goes beyond 24 weeks,
Right.
she'll still be using sick leave, but
And she didn't, it doesn't look like she used, if you want to get back under FMLA, intermittent leave, here for a week, gone for a week, where that could extend out over a year, right? Over a 12-month period. It just looks like she was just gone for all that time and couldn't come back until November. She did also raise other things, but the court says, look, the employer reasonably accommodated her. They kept extending the leave, and that was a reasonable accommodation. I thought that was good because they could have,
and
right?
they
They could
did
have said,
meet
I'm
with her.
sorry, you're out of leave.
They met with her. They engaged in the interactive process.
Yep. And which everybody, you and I say this all the time. When somebody presents with or could be assumed to have a disability or appears to be disabled, you better have an informal meeting to talk about how you can reasonably accommodate it, or you are dead at square one. If you don't have that meeting, it's an informal meeting, but you got to at least ask, is there anything reasonable we could do to accommodate you? And here they did that. They gave her time off. And the position she wanted, which again, there was no right to preserve, they filled them already. So, and that's what you should do. Well, I'm not saying what you should do, but if you have somebody on FMLA, take the more stringent test, and they run out of their 12 weeks, and you need to fill the position, you fill it. If you allow them back, they're no longer entitled to their position. I'm sorry, we're happy to hire you back, but we don't have the position. So this was definitely the right holding. And there has to be some people feel badly for the employee, but I feel badly for the employer. We're already holding your position. We got to fill it at some point. One employee can't stop us from doing what we need to do. We need people in the position. And it's the tough thing about FMLA, which is why it's only 12 weeks,
Mhm.
is we got to get someone in the position. It's not fair to them to promote them and then they got to go back to their old position, right? The employer's got valid concern. So FMLA is like a balancing act. But this wasn't FMLA. I just assuming that California is
And
about to take
and I'm assuming like our state, my state goes 1 week. We have 13 weeks
okay.
under the Rhode Island's family
One more.
leave act. So I'm imagining California probably has something probably a little bit more protective for the employee.
Okay, last one, and I'm just telling you right off the bat, I totally disagree with this holding. I hope you totally agree with it. So it's more interesting conversation. But we've got the Fifth Circuit down south, like by Louisiana and such, upheld the termination of a chief. So again, affirmed the right the trial court's decision. The city
Texas
official,
is Texas, man. Texas is Texas. It's tough down there.
man, I just disagree with this. I think this is wrong. But I maybe one small part of it, but it didn't justify termination. So here's what happened. He gets a subpoena, right? The facts are so simple. He gets a subpoena to testify, I don't want to say on behalf of, about another employee who was engaging in some misconduct, I think. And he fails to tell his employer that he's going to be testifying. And look, you should have, right? Whether that justifies termination or not is not really what happened here. But and he testifies, but he goes in uniform with his duty car and testifies favorably, I think, about the employee. And he gives this. It looked like he was publicly supporting an employee who had secretly recorded others in a fire station bathroom. I'm not saying the employee was right, but I think he was terminated, right? But he's up on criminal charges or whatever, and he's that employee who secretly recorded people is being investigated. And now this chief goes and testifies about him without telling anyone. The part I disagree with is one is, look, you're subpoenaed to testify. You are going anyway. So one, to terminate someone, fine. They didn't tell you, okay, maybe that requires some discipline, right? Next time you will tell us. But they act as if the opinion he gave, which was favorable to this, bad employee, was like a choice. If you're asked a question, you give an honest answer, especially while you're under subpoena. So he testifies favorably. Well, then it was his honest opinion. And he tried to say, this is what I disagree with. He tried to say, well, it was, First Amendment speech for protected under the Pickering test. Well, clearly it wasn't. He was subpoenaed as an employee. He was speaking as an employee. It's not protected speech. I agree with that. But how do we not have some rule that says when you're subpoenaed to testify and you give honest testimony, even if your employer hates it, that you somehow aren't protected? That is insane to me. Yet I couldn't come up with a law that protects that.
No, and I think the case we use out of Randolph, Massachusetts, the Chief Foley case out of Randolph, Massachusetts, where he was at a press conference and he made certain statements that the elected officials didn't like, but they were truthful. And he was asked a question and he answered the question, and no First Amendment protection because you're speaking in your capacity as the fire chief. But I think there's got to be more to this, because I think the way you're looking at it, you're assuming that he went there in good faith and testified truthfully.
He wasn't brought up on perjury charges.
And according to him, he admitted he got the subpoena, but he was told that this was an assignment of counsel case. So the hearing was going to be for assignment of counsel, that the guy must have had a public defender or something, and was going to get reassigned. He was also being violated. He was on bail, and his bail was being violated. So that was another part. It wasn't the merits of the case so much. It was more about whether or not he should be violated for something else. So bottom line is, one way that this case could have happened is that this guy did nothing wrong, and the city was just looking for an excuse to get rid of him. And he made a little slip up here, and that he should have notified him. Okay. There's another way that this could have happened, and it has to do with whether or not the elected officials felt that this guy intentionally did this, and he knew that his employers would be upset with him getting involved in this, and he was deceitful in terms of him testifying and only told them afterwards. So, and again, it could possibly be we've got the chief sees it one way and the elected officials see it a different way. You would think that reasonable minds could come together here and just say, okay, there was some sort of a misunderstanding, but it doesn't seem like, that somewhere along the lines, it's up at the Fifth Circuit. So somewhere along the lines, they couldn't get together on what they could agree on. And I think it's unfortunate. I agree with you. If he was truthfully testifying, he's responding to a subpoena, and the bosses didn't like what he said, that should not be a terminable offense. It shouldn't be. But on the other hand, if he was deceptive or perceived as being deceptive in terms of how the whole thing went down, that's a different story. I would want my subordinates to be honest with me and forthright, and not sneaking around behind my back.
Right.
So,
and I'm not beating up, the fire department. That's not my goal. There's something missing, as you said, why he's terminated for this. It's not just going and giving what he perceives as honest testimony pursuant to a subpoena, right? And that's very different, much stronger than the case you shared out in Massachusetts, because there he didn't have to give testimony, right? If he's asked a question, he could simply say, I can't answer. Subpoena, you're answering the question.
I throw out a term. I said a revocation hearing. You know what a revocation hearing? I know what a revocation hearing is. A lot of people don't know what a revocation hearing is. Okay. In addition, this hearing was supposed to be for reassignment of counsel. You know what that is. I know what that is. I'm not sure the elected officials know. I'm not sure the fire chief knew. And so there could be some confusion in what's going on. And it's possible the chief felt like, I did what I did. I did it honestly. I didn't think I needed to notify him. Maybe I should have, but I didn't. And the chief is, and the elected officials are looking at the same video here of what happened, saying, you lied to us. And we think you lied to us. And it could be just a misunderstanding between the two perspectives.
It could be right, and I think if he was just deceptive, but I got to tell you, everyone instinctively should know. You get a subpoena, you're telling your employee or your employer you're going to testify. I
Right.
think that's that's one of my basic HR policies that I do, and I cite the law that says you got to give time or time off or you got to notify whatever. But just the same, I think everyone instinctually, without a state statute, knows you probably should tell your employer you're going to court.
If you're going in uniform and you're going to say, I'm Chief Barone,
Yep.
and yeah,
Yeah.
absolutely.
Anyway, well, that is it for this
Yeah.
week.
Yeah, it was a good week. We apologize for getting off late today. Brad was traveling, and we waited him out. We finally got him back home, and
All safe and sound in the lightning storm we landed in. So
all right, all
crazy
right. Well,
times.
that's going to do it for another edition of Fire Law Roundup. We'll see everybody.